may have wondered, can a landlord, rental agency, or housing provider bar me from renting with them because I have a criminal record? The short answer is that a housing provider can have narrowly tailored rules related to criminal records, but cannot have in place blanket rules that prohibit renting to anyone with any conviction or arrest for any charge from any time. These rules are known as the Fair Housing Act. It's a federal law that prohibits discrimination in housing based on race, color, sex, religion, national origin, disability, and familial status. Having a criminal record is not a protected class under the Fair Housing Act. However, because African Americans and Hispanics are arrested, convicted, and incarcerated at rates disproportionate to their share of the general population, criminal records-based barriers have a bigger impact on minority home seekers and can constitute race discrimination. There are two ways a criminal records-based barrier might constitute discrimination: intentional discrimination, or where there is no intent to discriminate, but there is an unjustified discriminatory effect. A housing provider commits intentional discrimination if he treats individuals with comparable criminal histories differently because of their race, national origin, or other protected characteristic. For example, if a housing provider tells a white apartment seeker that his criminal history won't be a problem and they can work around it, but tells a black apartment seeker that they never rent to anyone with any criminal history. Another example would be if a landlord rejects a Hispanic applicant with a forgery conviction, but admits a white applicant with the same conviction. In these cases, the housing provider's use of criminal records or other criminal history information is a pretext or cover for intentional discrimination. To prove intentional discrimination, the housing applicant has to show that they are a member of a protected class, that they applied for housing, that the housing provider rejected the applicant because of their criminal history, and that the housing provider offered housing to someone with a similar criminal background who was not a member of the same protected class. A housing provider's policy or practice also violates the Fair Housing Act if it has an unjustified discriminatory effect, even when the provider had no intent to discriminate. Proving this can be a more involved process, but starts with filing a complaint with the Department of Housing and Urban Development, who will then investigate the claim. If HUD determines the policy does have a discriminatory effect, it must then determine if it is necessary to achieve a legitimate interest. This is the chance for the housing provider to prove that his policy is necessary and explain the reasons behind it. An example of this would be a policy that is narrowly tailored to address a specific concern, such as barring tenants with criminal convictions related to violence or property damage in the past 5 years. This shows that the housing provider has a necessary interest in keeping his property and tenants safe. Another example of a policy with a legitimate purpose would be an exclusion of individuals convicted of illegal manufacture or distribution, not just possession of illegal drugs. An example of a policy that does not serve a legitimate interest would be a blanket ban that bars all applicants based on prior arrest, since an arrest without a conviction does not prove that any misconduct actually occurred. Blanket bans on any and all prior convictions are not going to be found acceptable because they don't take into account the type of conviction, so it would be difficult to prove it was meant to address a specific legitimate interest, such as tenant safety. Also, blanket bans don't take into account the amount of time that has passed since the criminal conduct occurred, especially in light of research showing that, over time, the likelihood that a person with a prior criminal record will engage in additional criminal conduct decreases. Even if the housing provider successfully proves that his criminal history policy is necessary to achieve a substantial, legitimate, non-discriminatory interest, the home seeker still has an opportunity to show that the housing provider's interest could be better served by offering or suggesting a more narrowly tailored, less discriminatory policy that will have less impact on minority home seekers. In short, the Fair Housing Act allows providers to have narrowly tailored rules related to criminal records, but intentional discrimination is prohibited. Likewise, unintentional discriminatory effects can be investigated to ensure they are not unnecessarily barring home seekers with criminal backgrounds equal access to housing. For more information about the Fair Housing Act, visit hud.gov or idaholegalaid.org. If you are an Idaho resident and have fair housing questions, you can speak to an attorney for free by calling Idaho Legal Aid at 1-844-804-0386. If you want to file a Fair Housing Act complaint, you can do that by calling HUD at 1-800-669-9777 or 1-800-927-9275 for TTY, or by visiting HUD.gov.